folks, we're going to go ahead and get started, so you can make your way to a seat. I'm Robert Kilmarks. I'm the director of the Salt and Light Institute. Thanks so much. But the thanks go to you. Thanks for coming out and for being here. And on behalf of all the sponsors for this event, the Tennessee Judicial Reform Initiative, Faith and Freedom Coalition, Black Road Regiment, 912 Project Tennessee, and Gideon's Army. We just want to welcome you here. This is a very important topic and one that a lot of us are woefully unprepared to fight some of the battles that must be fought. So first step is education, and that's what we're going to do is provide some education for you. But as is our custom, before we get started, let's go to the Lord in prayer. And I'd like to call up Lieutenant Colonel Courtney Rogers, who is an amazing lady, and she's I've seen her open in prayer several times, so I asked her to honor us with a blessing.
Dear Lord, we are gathered here today to praise and glorify your name, to thank you for the privilege of being part of a nation where we are still free to worship you in the open. We thank you and we pray for our military men and women who even now are sacrificing their lives all over the world in the call for freedom. And we pray that their sacrifices are not in vain, lost to a godless and apathetic nation. For it has been declared to the world by our own leadership that we are not a Christian nation. So today, Lord, we ask you to grant us courage that we may unite as citizens, as Christians, to offer our resources, our leadership in our lives in answer to your call. Restore me. Restore me in your hearts. Restore me in your homes. Restore me in your schools and at work. Restore me in your city halls and state capitals. Restore me in the Supreme Court. Restore me in the halls of Congress, the House, and the Senate. And restore me in the White House itself. Lord, we know without you as our guide and our counselor, our people will never be as free as they once were. And our nation will never be as strong as it once was. So as was told to King Solomon, Lord, we humble ourselves before you and ask for your intervention to heal this nation and help us protect the Constitution that we now must defend. For we know that none of the blood shed by our military brethren, past, present, or future, could ever buy the freedom purchased by the blood of your Son, Jesus Christ. And we thank you for the words of encouragement left to us through the Apostle Paul. If God is for us, then who can be against us? If God is for us, then as a people and as a nation, we will prevail. Today, Lord, we stand without fear and proclaim your dominion over our laws, our leadership, and our land. In your name we pray. Amen. Amen.
Thank you, Courtney. A perfect example of a citizen who has felt the calling and the need for change in this country. So Courtney has thrown her hat in the ring and is running for the 45th district. And if I could ask you to stand for the Pledge of Allegiance, please. I pledge allegiance to the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. And I just wanted to spend just a minute, a couple housekeeping notes, and then tell you a little bit about Salt and Light and what we're trying to do here in terms of education. Bathrooms, just so you know, are out either one of these doors, the other side of the hall. Is the temperature okay in here, folks? Reasonable? A little warm? Okay. We'll cool it down some. So Salt and Light, what are we doing? We're here to try to provide educational opportunities on a wide variety of topics. Last month we kicked off this initiative with Bill Federer and Bill Warner on two courses on Islam. And then Courtney did one, Foundations of Liberty, for us, which I'm going to talk her into repeating pretty soon because you folks need to hear that. It is great. It's a 4-hour session, weekend session, but we want to do that again. And this initiative, and it's kind of unique or ironic the way this came about. We started laying out programs for Salt and Light. We want to do civics programs and teach history. We want to reach homeschoolers here. Just reach out to the community. And one of the initiatives we were wanting to focus on was on judicial reform because it is one of the top 3 threats, if not the greatest threat to our freedoms and liberties. And through a mutual acquaintance, I met a lady named Janice Johnson who has been fighting this, who was terribly abused by the court system, and she started a personal battle, a 5-year battle lobbying for judicial reform. We've gotten as far as she's gotten as far as she could go in the legislature. Now it's time to mobilize an army, but before we can mobilize, we have to be educated. This is a topic, it's hard to get your head around just how insidious the court systems are. So with that, I'm going to bring Janice up and she'll give you a little bit of history about what she's been doing for these past 5 years and the state of the affairs. And some of the current bills, there are some bills that are being debated right now in the legislature that need our attention. So this event tonight is kicking off a series of events that we're going to have here to provide educational opportunities for you. I mentioned Bill Federer earlier. Bill will be back in June, if I can't get him sooner, to do another series on judicial tyranny. He was a co-writer of a book by Mark Sutherland called Judicial Tyranny. And then we also have another contributor to that book, Ben Dupree, who is Judge Roy Moore's attorney, and he's been with the Moore Law Institute for a number of years during that whole time when Judge Moore fought the battle to keep the 10 Commandments in his courtroom. And unfortunately he lost that battle, but we got to change these kind of things. So with that, I'm going to bring Janice up and she'll give you a little bit of history of what we're confronted with right here in Tennessee. But thank you for being here.
I'm Janice Johnson. I'm heading up the Tennessee Judicial Reform Initiative, and I'm going to do something really radical tonight. I'm going to read from the Tennessee Constitution. Article 1, Section 1, that all power is inherent in the people, and all free governments are founded on their authority. Is that hard to understand? And instituted for their peace and safety and happiness, for the advancement of those ends, they have at all times an unalienable, indefeasible right to alter, reform, or abolish the government in such manner as they think proper. Does anybody understand what that means? Is that hard to understand? That is Article 1, Section 1 of your Constitution. You have the authority to abolish your government at any time. Let me read from the section regarding the judiciary. This is Article 6. It's the Judicial Department. It's Section 3. The judges of the Supreme Court shall be elected by the qualified voters of the state. Does anybody have a hard time understanding what that means? No. Okay. I'm going to read Article 6, Section 4. The judges of the circuit and chancery courts and other inferior courts shall be elected by the qualified voters of the district or the circuit to which they have been assigned. Does anybody have problems understanding what that means? Okay. I don't think it's hard to get your arms around this. This is the Constitution. It's very clear. Let me read one other section. It's Article 6, Section 2. This is the Supreme Court shall consist of 5 judges, of whom not more than 2 shall reside in any one of the grand divisions of the state. So you can't have all 5 from Middle Tennessee, okay? 2 from east, 2 from middle, maybe 1 from west, or 2 from west, 1 from middle, 2 from east. That's what it says. The judges shall designate one of their own number who shall preside as the Chief Justice. The concurrence of the 3 judges shall in every case be necessary to a decision. This is the important part. The jurisdiction of this court shall be appellate only, under such restrictions and regulations as may from time to time be prescribed by law. Who makes the law? You do. But it possesses such other jurisdiction as now conferred by law. Who makes the law? You do. On the present Supreme Court, said court shall be held in Knoxville, Nashville, and Jackson. Basically, it says the General Assembly has the authority to void anything they do and to regulate their jurisdiction. Because this is a government for the people, by the people, of the people. You can amend it, and read it again, alter, reform, or abolish the government at any time. Now, those are just real simple things, and you got your arms around real quick. And it took me 26 years to get my arms around that. I've been a citizen activist for 26 years. For 21 of those years, I was fighting on the wrong hill. I was getting people elected to public office and lobbying the bills through that affected people. Then the Lord saw fit for me to walk through the courtroom. And what I saw, I couldn't believe. I had no idea that there was so much power, so little oversight, and so out of control going on in the courtroom. So I've been, 5 years ago, the Lord redirected my energy to reigning in the judiciary. We have had 5 years of testimony before 6 different committees in the House, in the Senate, and the House Judiciary, the Senate Judiciary, Joint House and Senate, Government Operations, Children and Family Services, about out-of-control judges. The legislature is not, we haven't impeached a judge in 54 years. We haven't removed a judge in 18 years. The legislature is not familiar with this process, nor are they familiar with the fact that they can abolish these courtrooms at any time. And so it has been my personal calling to try to familiarize them with that process. Unfortunately, this past year, the judges have lobbied heavily, hired full-time lobbyists, and shown up down there lobbying every legislator, feeding them propaganda, and I'm out of my league. It is like Custer's last stand down there. I mean, I'm overwhelmed. So I went to Robert and I said, Robert, we've got to do an education campaign. We've got to educate the public about what's happening and what we can do to restore justice to our courtrooms. And that's why we're here tonight, and we'll have a series of lectures after this so that people can be educated about where we are, what's wrong, where we need to go, and David Barton is going to share the history of what our founders had intended for this nation in our judiciary and what you can do about it. Before I do that, I want to say thank you to Marlene Tidwell with the Tennessee Governmental Prayer Alliance, because I wouldn't be here if she wasn't praying for me. Where is she, Marlene? Please stand up and wave. Where are you? Oh, okay, there you are. Please pray. Thank her. Thank her. I would not be here today. I also want to say, are there any legislators here tonight? Thank you. Pray for them. The fact that this is a very, very, very busy time of year, and the fact that they came here tonight in their very busy schedules to hear what David's about to present is a gift from God, and you need to thank them for being here tonight. These guys are solid, and just shake their hands and thank them for being here tonight. And I want to thank you for being here. David, he's just amazing. Most of you know him. He's got 100,000 original writings on the Founding Fathers. He's written many books on the Constitution, and he is there. I could go on for hours, but I don't want to take from his time. He is awesome. So thank you all for being here tonight. David.
Three branches. It doesn't matter whether you're legislative, executive, or judicial. All of them answer to the people. Now, the way we've created judicial systems today makes it really tough for judges to answer to the people, especially when there are not elections of judges. It's hard, and the federal system is so different from what the Founding Fathers intended, and I'll show you some of the clauses of the Constitution, show you how we've changed that over years. They're just not very accountable anymore to the people. Now, all these state constitutions were written. When we get to the federal Constitution 11 years later, you have delegates like Charles Pinckney from South Carolina and James Madison from Virginia said, we're taking all this stuff we learned in the state constitutions, we're putting it in the federal Constitution. So you find the judicial clauses of the state constitutions make it into the federal constitution, and they dealt with a number of issues. And this is one of the things that a lot of folks miss today is you cannot understand the Constitution if you don't understand the Declaration. There's been a real effort to separate the Declaration from the Constitution, and I can understand why. For secularists, values are all over the Declaration. The reason the Founding Fathers didn't have to put values in the Constitution was they put it in the Declaration. Article 7 of the Constitution incorporates the Declaration into the Constitution. You didn't need to be redundant. You didn't have to say it twice. Now, if you want to say that there's no values in the Constitution, you have to separate the Declaration out. And that's why it's come under attack a lot in recent years. You may have heard in New Jersey, they wanted kids in school to say the Declaration, but only after they had rewritten it. So they went through New Jersey and rewrote it to make it what they wanted it to be, not what the principles were. So it's offensive to a lot of people because of the principles that it does contain, particularly on limiting government. So having said that, you just cannot get a grasp of this without knowing that. A good example is if you want to know what any clause means in the Constitution, I love the way the Supreme Court used to do this. They say, if you want to know what a clause means, what you have to do is determine the evil that was intended to be remedied by it. See, why is it that the Founding Fathers thought it was so necessary to protect the rights of conscience in the First Amendment? What was going on back then with the rights of conscience that made them think that they needed a constitutional amendment to protect it? Or why in the world did they give us a Sixth Amendment that said you have the right to confront your accuser? Well, what was happening back then see, if you can figure out what the evil was they were targeted at, then you find the original intent. Pretty easy to do. So, if you look at any clause in the Constitution, take Article 1, Section 5, Paragraph 4. You don't know what that means? Go back and find grievance number 4 of the Declaration. Here's the complaint they raised. Here's the solution they gave to it. Same thing all the way through the Constitution. If you don't know the grievance in the Declaration, you'll never understand the clause of the Constitution. It's that way throughout the document. The two things are related. So they give you 4 judicial abuses, 4 clauses where they say, well, we can't let judges do this. They go into the Constitution and fix that. Now, if you understand the 4 clauses in the Declaration, you can understand exactly what they were doing in the Constitution. So that's what I want to take you some through, is show you some of the things that they said about judges. And particularly, there's 6 judicial myths I want to take you through. So I'm going to try to run through these so we don't stay here all night. Run through those 6 judicial myths. The first one that we hear a lot about is that... Everybody heard that? Tell that to a Founding Father, you better duck, because they would punch you if you said that to their face. They made it very clear. So now, I love the people who tell us the branches are co-equal. It's the judges who tell us the branches are co-equal. They wish it were, and that's why the Supreme Court website. Framers of the Constitution created 3 independent and co-equal branches of government. You get that all over the legal websites. Now, let's go to the Constitution and see what the Constitution is. By the way, the best commentary on the Constitution was actually the Federalist Papers itself. Federalist Papers written by James Madison, John Jay, and by Alexander Hamilton. These 3 guys wrote it. And if you look at the Federalist Papers, how good a commentary is it? I love what Madison said about it. James Madison said this. He said, the Federalist may be fairly enough to be regarded as the most authentic exposition of the heart of the Federal Constitution as understood by the body which prepared and the authority which accepted it. He said, this is the best commentary on what we were thinking when we wrote it and what they were thinking when they ratified it. This is what we were all thinking when we did this. So you read the Federalist Papers, you get really clear what they were thinking in every clause, and it addresses all of them. So say, all right, what did they say about co-equal? Well, first off, Federalist 51 tells you the legislative authority necessarily predominates. Got news for you, if one predominates, they can't be equal. If one's more powerful than the other, they cannot be co-equal. They told you up front, we created this thing where the legislative body has the most power. It's not equal with the others, it is above the others. And just to make sure we understood that, you go to Federalist 78, and they say the judiciary is, beyond comparison, the weakest of the 3 departments of power. Now, how can it be co-equal if they created one strong and one weak? It can't be. And by the way, how weak is it? Beyond comparison, the weakest. And how weak is that? It says the general liberty of the people can never be in danger from that quarter. We made sure judges are so weak that people are never going to have to worry about judges. We've had with Great Britain, we created America where judges can never have any power to affect the liberty of the people. Really? Not in the last 50 to 60 years. But then again, who reads the Federalist Papers? Who studies the Constitution? See, this is real clear stuff. This is not hard to dig out. They were very clear about this. Continue. They said the judiciary has no influence over either the sword or the purse. It has no direction over the strength or the wealth of society, and it can take no active resolution whatsoever. It may be said to have neither force nor will. That's pretty weak. No wonder the judges keep saying, hey, we're co-equal, we're like you guys. No, they were never designed to be, for the very fact that judicial abuses are harder on people than any other abuse. It's harder to get rid of judges than it is anything else. That's why you give them less power. Because if they're not accountable people, they really can abuse power. So that's the notion of co-equal branches. Now, if one predominates and the other's weakest, they can't be co-equal. So there's nothing in the Constitution, nothing in the Federalist Papers, nothing in the Founders' thinking that said we have 3 co-equal branches. This guy, William Giles, a significant founding father. He is actually one of the very first members of the very first Federal Congress. So we have the Constitution. Now we've got to make it work. We've got to put it in effect. He's one of the first members. He actually is one of the guys who framed the Bill of Rights. He actually is the guy with the first ever judiciary bill in the United States. First time we create a judicial system under the Constitution, he's the guy on the bill. He served under George Washington. He served under all the early presidents. And in the middle of the judiciary debates on the bill, notice what this First Amendment guy said. I say Bill of Rights. First Amendment, all the Bill of Rights. Notice what Giles said. He says, superficial observers take it for granted that the 3 departments of the government are coordinate and independent of each other. Everybody says, oh, they're 3 co-equal branches. He said, people just think that. He says, it's to be observed that the words coordinate, independent are not to be found in any part of the Constitution. There's nothing in there that says the judges are coordinate, or in other words, co-equal with the other branches. He says, according to the Constitution, the establishment of the Judiciary Department was entrusted to the Legislative Department. Is the Judiciary Department formed by the Constitution? It is not. It's only declared that there shall be a department. It's directed to be formed by the other departments who are responsible to the people. Now, notice what he's going to say here about how this works. He says the number of judges, the affirmation of duties, the fixing of compensations, the fixing of the times, when, and the places where the court shall exercise the functions, that's all left to the entire discretion of Congress. And see, Congress gets together, they can say, here's what our salaries are going to be, here's how long we're going to meet, here's what issues we'll deal with. Judges can't do that. When judges get together, they can't set their own salaries. They can't even say how many judges are going to be in the state. They can't even decide what issues. The legislature has to tell them all of those things. The legislature says, okay, here's your salary. Here's the issues you can deal with. Here's the ones you can't deal with. Here's how many judges there are. We're going to have this many chancery judges, this many appeal judges. That's told them by some other body. They don't even get to make those decisions for their own body. Now, the legislature does. They're the most powerful. These guys are weakest. They can't even set their own rules and regulations. It continues. Congress may postpone the sessions of the court for 8 or 10 years, and Congress can establish other courts to whom they can transfer all the powers of the existing courts. It says, the spirit as well as the words of the Constitution are completely satisfied provided one Supreme Court be established. The only thing the Constitution requires is a Supreme Court. It doesn't even tell you how many members on the court. Congress is the one who says how many members. George Washington started. The first law given by the federal Congress said you get 1 Chief Justice and 5 Associate Justices. So George Washington appointed 6. It's gone up or down since that, sometimes 8, sometimes 9, proposals for more than that. That's totally Congress's call. I love the way this is said by Steve King. Steve King's a good friend of mine. He's a congressman from Iowa, and Steve King's on the Judiciary Committee. And Steve gets this. He, bless his little heart, he actually reads the Constitution, and worse than that, he went back and read the actual Judiciary Act of 1789, and then the second one they did of 1802, where all the Founding Fathers talked about judges. And he gets this, and this is what he said. He said, constitutionally, Congress can reduce the judiciary to nothing more than Chief Justice Roberts sitting at a card table with a candle. You see, quite frankly, the Constitution says that all inferior courts below the Supreme Court are established by Congress. Congress can decide if there's going to be any courts, no courts, how many courts there will be, what kind of courts of appeals. Gingrich is out there saying, let's divide the Ninth Circuit, and all these law professors and attorneys say, you can't do that. Read the Constitution. You can't do that. There's nothing required in the Constitution except a Supreme Court. Doesn't even tell us how many members. Now, the other thing the Constitution requires is what's called original jurisdiction. There are certain cases that have to go to the Supreme Court. Lawsuits between states, lawsuits between America and another government. Other than that, Article 3, Section 2 says that Congress gets to determine every issue that comes before the Supreme Court. It's called the Exceptions Clause. That's what Janice read earlier about your justices. They can't decide on anything except what's given them by law to decide on. And if you pass a law that says, we've just decided abortion doesn't go to your court, there's nothing they can do about it because it's established by law. See, that's an easy solution if the Congress would ever do that, but of course nobody reads the Constitution, but if they did that, the exception, and that's been done 200 times in history, where Congress passed a law that says, Supreme Court, you're not allowed to review this law. This is the final word. Keep your hands off it. It's real easy. That's how you kept them the least significant branch. So the first myth is 3 branches are co-equal. That is not true. That's constitutionally not true. Historically, it's not been true. It's become true in the last 50 to 60 years. Second myth I would point to is judiciary is an independent branch. Now, we hear that all the time, and again, who tells us that? It's all the judges and attorneys who tell us that. Back to the Supreme Court website, the framers of the Constitution created 3 independent and co-equal branches of government. We've already dealt with the co-equal, now let's deal with the independent part. And by the way, the American Bar Association is happy to chime in. Judicial independence is freedom from direction, control, or interference in the operation or exercise of judicial powers by either the legislative or executive arms of government. Let me see if I get this right. If there is judicial independence, that means the other 2 branches can't mess with you. Now, they're saying all 3 branches are equal, right? And so they're saying judicial independence means the other 2 branches can't mess with us. Okay, if all the 3 branches are equal, then that means judicial independence. Let's change that a little. Let's put legislative in. Legislative independence is freedom from direction, control, or interference in the operations or exercise of legislative powers by either the judicial or I don't think the judges would agree that they shouldn't touch the legislative laws. They love to strike down laws. They love to deal with all the issues. They're happy to jump in the other 2 branches, but they don't want the other 2 branches jumping in them. So while they say we're co-equal, they don't even believe that, because they believe they have the authority to strike down the acts of the other 2, but the other 2 don't have the right to tell them what to do. So that's not even co-equal on that basis. So having said that, the independent, no. They're not an independent branch of government, even though they love to say that. And again, turn back to this thing, judicial independence, that's what American Bar Association claims, doesn't even hold up under their own definitions. So back to William Giles, the guy who did the first Judiciary Act. Look what he says. Continuing on, he says, they tell us they can see in the Constitution, and they call on us to see also written therein, in large capital letters, the indefinite independence of judges. In other words, they say, oh, it's in the Constitution. They want us to see it, and they claim it's there, and it's not written there. He says, which to the extent they carry the meaning of the term is neither to be found in the letter or the spirit of that document. With respect to the word independent as applicable to judiciary, it is not correct. It is not justified by the Constitution. An independent department of government is conceived to be a department furnished with powers to organize itself and execute the peculiar functions assigned to it without aid, or in other words, independent of any other department. They can't do that. They can't even put themselves on the courts. It takes somebody else to put them on the courts. So they're not independent. They can't operate themselves. The other branches are what operate, and it was by design. That's the way the Constitution did it. A moment's attention to the Constitution will show that this is not the constitutional character of our judicial department. It's not an independent branch. Now, I love the way John Dickinson, here's John Dickinson, the signer of the Constitution. He was a general in the Revolution. He was the governor of Delaware. He was the governor of Pennsylvania. He's a big-time founding father. John Dickinson said this. He says, what innumerable acts of injustice may be committed, and how fatally may the principles of liberty be sapped by secession of judges utterly independent of the people. It sounds kind of like prophecy, doesn't it? He said, man, if you ever get judges independent, he said, there goes your liberty, there goes all these injustices that are going to happen. You can't have judges that are independent of the people. I love the way Jefferson said it. He said, he said, it should be remembered as an axiom of eternal truth in politics that whatever power in any government is independent is absolute also. That's why they didn't want an independent judiciary. Whatever power is independent is absolute. That's why all 3 branches were to be controlled by the people. They're to be accountable to the people. Otherwise, they become absolute. He says, independence can be trusted nowhere but with the people en masse. The only absolute here is the people themselves. Not any other branch of government gets to be absolute. So that's judicial independence. They did not buy into that. That is a myth. Third myth I would point you toward is the myth that elections to judiciary make it too political. Now, that's how the Tennessee plan is advanced right now. It's being proposed in your state that you should also go to the Missouri plan. And the Missouri plan says, let the governor have a selection of people, and he'll put them up there, and then they'll come up for retention elections later, etc. So, the reason given by attorneys is, no, if you have judges run for office, it makes them too political. Thank you. It makes judges too political if they run. Anybody want to tell me that judges right now are not political when they don't run for office? Has anybody got the audacity to say that judges do not have political agendas just like anybody else? Amen. Give me a break. That's human nature. You see, that's what the Founding Fathers understood back then. Thomas Jefferson said this. He says, our judges are as honest as other men and not more so. They're just as subject to political agendas as anybody else. He said, they have, with others, the same passion for party, for power, and for the privilege of their core. They're going to protect themselves just like a legislator will, just like a governor will, just like a bureaucrat will. It's human nature. So therefore, since that's human nature, Don't buy into the thing that, oh no, if we have to run for election and raise money, that would make us a political branch. Got news for you, you are a political branch. You're already a political branch. So much policy we have in America today did not come from legislatures anyway. We have not had a single legislature in the United States ever pass abortion on demand. It's national policy because judges told us it was. We've never had a legislature in the United States tell kids they can't pray at a football game, but it's national policy because the judges told us that was national policy. It was the whole gay marriage thing came from judges saying, hey, we order you to recognize. You know, tell me that's not political activity. And tell me they don't tell me the debates that happen today on Obamacare don't have politics involved in them. And tell me that I can't tell you which side the justices are going to come down on based on their political predilections. We know that. That they are. That's why you still want them accountable. Because if their politics is wrong, you can throw them out of office. If they're retained or appointed, you can't throw them out of office. Continue. He says, and their power is the more dangerous as they are not responsible as the other functions are to elective control. And that's the point. They get agendas, and if they're not elected, you really lose control. Now, at this point in time, he had been ambassador to France. France has gone through 3 revolutions while he's Secretary of State, and France is saying, what should we do with our government? How should we create our Constitution? Notice what Jefferson said about elections. He says, we think in America that it's necessary to introduce the people into every department of power, every department. He said, now, were I called upon to decide, if you were to ask me, should the people best be omitted in the legislative and judiciary, should we leave the people out of choosing their representatives or leave the people out of choosing their judges? If you're going to say, let's not have an elected legislature, let's have an appointed legislature, or let's not have elected judges, let's have appointed judges. If we should leave the people out of one of those 2 branches, he says, I would say it's better to leave them out of the legislature. Wow. He said the execution of laws is more important than the making of them. If you're going to have somebody that's not elected, let it be legislators, but don't let it be judges. See, that's the mentality again, is judges are more dangerous because the very nature of their office. So if you're going to not have elections, let it be for legislators, not for judges. So that's the philosophy they had on that. James Wilson, signer of the Constitution and the Declaration, huge civil rights leader in Pennsylvania, great guy. James Wilson also was appointed to the U.S. Supreme Court by George Washington, one of the original 6 justices. He started the first law school in America. This is what he taught students about the judiciary. He said, students, here, the people are masters of government. Elsewhere, the government's master of the people. Bottom line is, people run the government here. All branches of the government, including the bureaucrats in the government. Elsewhere, the government runs the people. And that's the way it was across Europe. So the philosophy, again, was you don't let any branch run the people. The people run all 3 branches. So when you go back to this, that's why you have Declaration of Rights, Article 5, that whatever the branch is, whether it's legislative, executive, or judicial, they're all times the agents of the people and accountable to the people. That's why your Constitution had the election of judges in it. That was typical for all the states to have elected judges. Back in the 50s and 60s, the Missouri plan came through and your Tennessee plan came through in 71. Nonetheless, this is constitutionally the way it was set up and the way it was designed to be. Now, the reason I like election of judges is a Bible verse that was the basis of the 6th Amendment of the Constitution. The one I mentioned earlier, why do you have a right to confront your accuser? Why do you have the right to do that? The Bible verse tells you real clearly what it is. He who states his case first seems right until someone tells the other side and sets the record straight. You know how that is with your kids. Kids come home and tell you what happened, and you get the other side of the story, and the kids weren't the victims after all. They were the ones who created the problem. You had kids, you always wait for the second side of the story. That's the way the courts work. When one guy makes his appeal and presentation, it's really powerful, but I want to hear the other side. See, that's what happens when you have elections for judges. You have an opponent that gets to point out what this guy did while he was on the bench and all the crazy, goofy things he did, and then people say, oh yeah, I forgot he made that decision 22 months ago or 3.5 years ago. And so having an opponent gets to tell the other side of the story. And then people get a real clear, educated, informed choice of what kind of philosophy they want on the bench. It's a real easy thing. So that's the way politics works. That's the way we elect our representatives and senators. They run against somebody else, and we get to choose which philosophy we want in the House or the Senate or anything else, because there is a political philosophy with every branch of government. There's just no way around it. So elections make the judiciary too political? Nonsense. That's the third myth that we've kind of bought into. The fourth one that I'll point out is the myth that says, well, only judges are capable of determining constitutionality, and their primary responsibility is judicial review. Now, this concept that judges get to determine what's constitutional and that they do judicial review, let me take the latter part first. Let's go to judicial review. Now, as a final arbiter of law, the Supreme Court functions as guardian interpreter. See, here's the thing. We get to decide what's constitutional and what's not. We'll tell you guys which laws pass muster. You have here on a card encyclopedia, the Supreme Court's principal power is judicial review. This is why the court exists, to review the laws. And the right of the court to declare laws unconstitutional. The court exists to review laws and tell us whether it's constitutional or not. Really? Now, that's what we're told today. Let me take you back to the origin of judicial review. Anybody remember from civics class where judicial review got started? Marbury versus Madison. John Marshall, third Chief Justice, U.S. Supreme Court, has a case called Marbury versus Madison, 1803. That's the basis, we're told today, of judicial review. That's what all the law schools teach us. It's an interesting thing. Let's go back to how Marbury-Madison even got to the court. What happened was this came out of the election of 1800, presidential election. In that presidential election, you have two guys running for office, John Adams, Thomas Jefferson. They're both the founders of two different political parties, the Federalists and the Anti-Federalists. So you've got these two parties and these two candidates running for office. People make their choice, and the people overwhelmingly chose the Anti-Federalists. They made Jefferson president, they chose an Anti-Federalist Senate, and they chose an Anti-Federalist House. The people said, we like this party over here. We like what they represent. So, with the Federalists having been thrown out of office, what happened was the Federalists said, okay, we're losing control, but we can do something to keep the judges there. So they went through and passed a bill that doubled the size of the judiciary. It went from, let's see if I remember this right, it went from 16 judicial spots to 33 judicial spots. So they doubled it and they said, we're going to put all of our Federalist judges on the courts. And so what they did was court packing. They doubled the size of the judiciary, they put all these Federalist judges on there, and John Adams signed all the commissions for these new judges, got it confirmed by the Senate, but they forgot to deliver the commissions to the judges. So when Jefferson's administration comes in, the Secretary of State comes in, James Madison, he sees all these judicial commissions to court-packed Federalist judges that haven't been delivered yet, and he says, well, I'm sure not delivering these. I'm not going to turn. And so at that point, one of the guys who had been appointed and confirmed, William Marbury out of Washington, D.C., on a court in Washington, D.C., actually a Justice of the Peace course in Washington, D.C., he said, they confirmed me in the Senate. Give me my commission so I can start being a judge. And Madison said, there's no way I'm giving you that commission. This administration's not going to honor that. We refuse to do that. And so he sued, took it to the Supreme Court, and that's how it ends up in front of Chief Justice John Marshall. Now, what's really interesting is it was the Secretary of State for John Adams that really made this case a problem. If the Secretary of State for John Adams had simply delivered those commissions, there wouldn't have been any question about it. But because the commissions were not delivered, now Madison says, well, I'm not going to deliver them, and that means you're not a judge. And so Marbury says, well, you should have delivered it because I was ratified this. So it all really goes back to the Secretary of State for John Adams who forgot to deliver the commissions. By the way, who was the Secretary of State for John Adams? It was a guy named John Marshall. But right after he forgot to deliver those commissions, he got appointed the Chief Justice of the U.S. Supreme Court. So now he's on the court to decide whether he should deliver the commissions or not. Now, in any court of law today, you'd say, you got to recuse yourself. That's a conflict of interest. What are you thinking? And today we take an unethical case. Anybody would agree that he should not have been deciding that. And of course, his decision was, well, the Jefferson's administration needs to deliver the commissions that I forgot to deliver. I mean, that's the decision, Marbury versus Madison, and on the basis of that, we do judicial review. Now, by the way, he didn't overturn a law. That's the first time that the courts told any other branch of government what they should be doing. Prior to that, courts could run the courts, but the courts couldn't run any other branch. The other branches ran themselves. And they could say, oh, no, the jury wasn't impaneled right, or no, you applied the wrong sentence here. You know, they could look at the courts, but they couldn't look at the other branches. This is the first time they looked at another branch, and they told Madison, they told President Jefferson, the executive, to deliver those commissions. Now, it's interesting. When it happened, Jefferson and Madison both called the decision a perversion of law. They both ignored it, and nothing ever happened. They ignored it, and nobody ever got mad at them for ignoring the Supreme Court. And by the way, Jackson ignored the Supreme Court. Abraham Lincoln ignored the Supreme Court. The Emancipation Proclamation, clear violation of Supreme Court ruling, as was declaring slavery illegal in Washington, D.C., as was I can go through all this, and Lincoln told you that he was going to deliberately ignore the Supreme Court in his inaugural address. I mean, real simple stuff. Now, why would they do that? I'm going to get to that in a minute. But I have to go back to this judicial review for a minute. I say that to say we never allowed the judges to run the other two branches, ever, period. Now, if you didn't like what the president did, throw them out and get a different president, we'll do it different. And that's okay. But judges may be there 40, 50 years, and that's a whole different thing. So that's why they regularly ignore them. Now, interestingly, 1857, the Dred Scott decision. Remember that abominable decision? That's the first time in the history of the United States that the Supreme Court ever struck down a law of Congress. The law struck down was passed in 1820 called the Missouri Compromise. The Missouri Compromise said, look, there's some territories we're not going to have slavery in the United States. Here's the line we draw across Missouri. Above that, you can't have slavery. Below that, you can't have slavery. The Supreme Court came in and said, no, that's an unconstitutional law. You can't stop slavery anywhere. As a matter of fact, that's the famous line the Supreme Court gave. It says, no black has any right which a white man is bound to respect. It says, you can't declare property free in any part of the United States. So the first time judicial review was exercised on a law was in striking down the Missouri Compromise and the Dred Scott decision. Tell me that's a good model to follow. So we now think judicial review is this really wonderful thing that happened. And you know, people say, no, wait a minute. The court does good stuff. I mean, Brown versus Board of Education, Ruby Brooks here, bless her heart, 6-year-old girl. I mean, they had to have 4 federal marshals to take her to school in Louisiana. It's nuts. But the court did a good thing in the segregation now. Let's back up a minute. Let me take you back to what happened in a law of 1875. In 1875, the Congress of the United States passed a law that says no segregation allowed anywhere. Not in transportation, not in housing, not in dining, nothing. Segregation is banned in the United States. Law passed in 1875. In 1882, the Supreme Court struck that law down and said, no, you can't ban segregation. Remember, blacks aren't people, so you can't ban segregation. 1882, they struck down the anti-segregation law that was passed in 1875. So, they said segregation, we think it's fine. So, do you know what Brown versus Board of Education is? That's just the Supreme Court reversing itself from 80 years earlier. If they'd left it to the people, segregation was ended back in 1875. It's the courts that kept it alive for 80 years. See, that's why the people are better guardians of liberty than the courts are. It's just real simple stuff. The people do a better job of protecting liberties than the courts, and I'll show you some other examples as we go through. So what you get in law school is an edited review that says, I'm just going to show you the best part, but I'm not going to show you all this Dred Scott stuff and all this segregation stuff. I'm not going to show you what the court did to that. Oh, courts need to strike down laws. No, that's nonsense. So here's what I dislike about this phrase as the final arbiter. We in the Supreme... I do tours of Washington, D.C. regularly, and anytime I take a group into the Supreme Court, once I get them out of that tour, I got to take them outside and wash their brains out because they've been brainwashed. It's bad. I mean, on the tour in the Supreme Court, they say, this is the building from which all the law of the land emanates. Time out. What's that big dome building across the street where they make law? No. All law comes out of the Supreme Court. Show me any civics or government textbook where the court makes law. It has to go to the House, it has to go to the Senate, it has to be signed by the President. No, the court says all the law of the land comes to this building right here. Now, the word that really gets me is the word the. We are the. We're the only ones who can tell you what the Constitution means. Then how come we started teaching the Constitution back in 4th and 5th and 6th grades? If it takes a law degree on the Supreme Court to know what it means, why do we teach it to elementary kids? It's not a hard document to understand. You don't have to have a law degree to understand the Constitution. Matter of fact, be surprised to know how many Supreme Court justices George Washington put on that didn't have law degrees. I mean, it was real... You just had to know the Constitution. That's what you do is uphold the Constitution. So, the final arbiter. Now, this is where the Founding Fathers went through the roof when that notion was raised back then. James Madison said this in the first Congress. The argument is that the legislature has no right to expound the Constitution. That whenever its meaning is doubtful, you must leave it to take its course until the judiciary is called upon to declare its meaning. I beg to know upon what principle it can be contended that any one department draws from the Constitution greater powers than another in marking out constitutionality. He says, nothing has yet been offered to invalidate the doctrine that the meaning of the Constitution may as well be ascertained by the legislative as by the judicial authority. Now, the guys who make the laws take an oath to uphold the Constitution. They didn't take an oath to uphold the Supreme Court's opinion of the Constitution. It's a big difference. That's part of the check and balance that happens. They can read that document, and they're responsible for making sure it's constitutional. Now, so what do you do with what's the role of the court? Well, let me take you to a Supreme Court decision from a few years ago. This is called a slip opinion. This is a Supreme Court decision, Georgia versus Randolph. This is back in 2006. And this decision, and here's how it starts out at the top. See what it says? Justice Souter delivered the opinion of the court in which Stevens, Kennedy... Why do they call it the opinion of the court, not the law of the court? It's an opinion. That's exactly it. All it is their opinion. What you used to do is say, the legislature say, man, we hadn't thought about that. Good point. All right, we'll go back and change the law. We respect your opinion because we hadn't thought about that aspect. But to give them the final say over it? No. That's why to this day it's still called the opinion of the court. They could issue an opinion, but it was not binding. You could consult it, consider it, say, that's good advice. We should have thought about that. We just did. That's fine. It's an opinion. That's all it is. Now we've made it the law of the land. Let me take you back to Elbridge Gerry. One of the guys, one of the 55 who wrote the Constitution, Elbridge Gerry said, it's quite foreign from the nature of the judiciary's office to make them judges of the policy of public measures. That's one thing they don't get to decide. That's why you pass laws. That's why the legislature does it. Judges don't get to decide public policy measures. Luther Martin, also one of the delegates of the Constitutional Convention, he said, a knowledge of mankind and of legislative affairs cannot be presumed to belong in a higher degree to the judges than the legislature. You can't think that they're divine and they know what the Constitution means. No. It's the people. We all get to understand this document. So John Randolph, he's an early congressman who served under all the early presidents. As a matter of fact, he is the first member of Congress to oversee an impeachment proceeding of a U.S. Supreme Court justice. This impeachment was of Samuel Chase. He's a signer of the Declaration. He's put on the Supreme Court by George Washington. They had an impeachment of a Supreme Court justice, and he's the guy who was the manager of the impeachment trial of the Supreme Court justice. And this notion that the court gets to have the final stamp, here's what he said about it. John Randolph said this. He said, if you pass the law, your judges are to put their veto on it by declaring it unconstitutional. He said, wait, let me get this straight. You pass a law, and you're saying that judges can veto the law that you've passed? He says, here is contended for a new power of a dangerous and uncontrollable nature. He says, the power which has the right of passing without appeal on the validity of your laws is your sovereign. If you let the courts have the final word, then they are your sovereign. There's nothing else higher than them if they get the final word on your laws. That's why the legislature gets the final word, because we can replace them. We're the final word on our laws, not the legislature. That's why we can send new people in. Jefferson said it this way. He said, the opinion which gives to the judges the right to decide what laws are constitutional and what not would make the judiciary a despotic branch. Yeah, I think so. He said, the Constitution of this hypothesis is a mere thing of wax in the hands of the judiciary, which they may twist and shape in any form they please. Yeah, because whatever their political position is, as today's hearing with the healthcare thing, they're going to twist the Constitution to fit what their views are. And if you give them the final word, then it'll become a thing of wax. They'll reinterpret it on a regular basis, and that's not to happen. So that's the fourth myth, is that they're the only ones who know what's constitutional and their responsibility is judicial review. The fifth myth that's out there deals with the aspect that federal judges hold lifetime appointments. How many of you have been told that? Again, if you ever told a founding father that, you need to duck. They said, are you completely illiterate? I mean, we told you in Article 3, Section 1 that they do not get lifetime appointments. It says the judges, both the supreme and inferior courts, shall hold their offices during good behavior. Anybody see lifetime in there? It says good behavior. As long as they act right, they can stay on the court. If they don't act right, they're going off the court. Now, that thing about good behavior, what does that mean? Well, actually, the guy who authored the judiciary bill in the first Congress, a guy named John Calhoun, who's the author of that bill, he's the guy who did the first judiciary bill under the Constitution. Here's what he said. He said, we all fully at once understand what good behavior is in the judge. And if he acts contrary, it's misbehavior. All right, the opposite behavior is misbehavior. I got it. He says, and the Constitution in that case has given a remedy by, all right, let's see. If a judge doesn't do what's good on the bench, if he misbehaves on the bench, the remedy is impeachment. And that's the word he used, impeachment. Now, interestingly, the Constitution gives you about 6 ways to control judges. One of the 6 ways is impeachment. Interestingly, it gives you 6 clauses on impeachment. There's nothing in the Constitution that gets more coverage than the single subject of impeachment. 6 clauses deal with impeachment. That must have been pretty important for them to put 6 clauses in the Constitution dealing with impeachment. Yeah, it was a big deal to them. Now, impeachment, what makes an impeachable offense? Well, when you look at what impeachable offenses are, you look at these clauses, say, okay, if I can read the 6 clauses, I think I'll get it. And by the way, I can also see the examples we've got, because we've had 61 impeachment investigations of judges. We've had another 36 of of executive branch people. We've had 13 impeachments. So if I can look at these, and I can see what an impeachable offense is. Now, you go back and look at the Founding Fathers, and what constitutes a breach of good behavior, or in other words, what's grounds for impeachment? Do you know what the Founding Fathers impeached and removed federal judges over? Let me show you what they did. Now, they wrote the Constitution. I think they know it's an impeachable offense. Judges they removed. The first federal judges removed. You just go down to the first 6 or so. Pretty interesting. First federal judge was removed for issuing an order contradicting an act of Congress. Is that what happens when they strike down a law? Did that, was thrown off the court. That was bad behavior for a judge to be making policy. Look at the next one. Drunkenness in private life. Whoa, that's private life. That has nothing to do with it. Yeah, it may be private life, but that's not good behavior for a judge. You want to sit good behavior, and that's bad behavior, so you're off the court. You impeach the guy for getting drunk in private life? No, keep watching. Rudeness in the courtroom to witnesses. That's not good behavior for a judge. Now, see, today, I've been through this with law school professors, and I've been involved in the U.S. Congress and helping work on impeachments there, etc. And we keep getting told by law school professors that no. The only way you can impeach a federal judge is if they commit a criminal felony. Okay, see. So you're telling me if he rapes his daughter and murders his wife, maybe we can impeach him. And that's the position. And that's why federal judges feel pretty untouchable. Because if it only takes a criminal, not even a civil felony, it takes a criminal felony to be impeachable, none of this. But this is what the Founding Fathers said. This is bad behavior. Look at this one. Try this with profanity in the courtroom. Bad behavior for a judge. You're off the court. This one, what they call judicial high-handedness. That was three judges. Acting like a tyrant in the courtroom. Yeah. See, that's how they intended the judges to be accountable. Now we say, oh, no, judges have lifetime appointments. You can't touch them. No. Your appointment is for the duration of good behavior. As long as you act right, you can stay there. You start acting wrong, you're off the court. It's real simple stuff. So, Joseph Story, who was the justice on the Supreme Court, put there by James Madison, did probably the best commentary on the Constitution other than the Federalist Papers. It's called three volume set called Commentaries on the Constitution. Did it in 1833, still available today. It's a great reprint to give. He says, all right, let me take you through the 6 clauses of impeachment. Let me show you every impeachment we've had up to this point. Let me show you what the grounds were. He says, none of it deals with criminal behavior. None. He says it all deals with a judge becoming too political in what they're doing. You impeach a judge when their political behavior starts coming through. This is what he said. He said, the offenses to which the power of impeachment has been and ordinarily is applied as a remedy are aptly termed political offenses, growing out of personal misconduct or gross neglect or usurpation or habitual disregard of public interest. There's nothing criminal about any of these things. This is all personal misbehavior. This is your politics acting wrong. I don't mean in the sense of what party or anything else. I mean, this is not criminal. It's personal, political stuff. Habitual disregard is, no, I don't like that. I like this agenda. Can't do it. That's impeachable. He continues, impeachment partakes of a political character as it respects injuries to the society in its political character. The constitutional provision on impeachment holds out a deep and immediate responsibility as a check upon arbitrary power. John Marshall, Chief Justice on the U.S. Supreme Court, look what he said. He says, the present doctrine is that a judge giving a legal opinion contrary to the opinion of the legislature is liable to impeachment. Now, he's the guy they quote for judicial review, and he's saying it's an impeachable offense to give an act contradicting an act of Congress? That's impeachable? How come they don't quote that in law schools? They quote Marbury Madison and don't even tell you the story. Then you've got Alexander Hamilton, author of the Federalist Papers. He says impeachment is a bridle in the hands of the legislature. This is how the legislature keeps judges under control. Each branch is furnished with constitutional arms for its own effectual powers of self-defense. The way the legislature defends itself is impeach judges who try to act like legislators. That's what we did in Iowa. We sent 3 judges home in retention elections. We said, these guys think they're legislators, so why don't you guys release them to join the legislature? They can run for legislature. And so we said, if they want to, and in their case, it was gay marriage. The 161 years, the law of Iowa said marriage is between a man and a woman, and the judges said, no, it's not. It's between any combination you want. And the people said, okay, you want to be legislators? You're free to be a legislator now. You can go run for the legislature, but you can't legislate from the bench. James Iredell, Justice on the U.S. Supreme Court, put there by George Washington, great guy. He says, every government requires impeachment. Every man ought to be accountable for his conduct. Impeachment will not only be the means of punishing misconduct, but it will prevent misconduct. He says, a man in public office who knows that there is no tribunal to punish him may be ready to deviate from his duty. But if he knows there's a tribunal for that purpose, although he may be a man of no principle, the very terror of punishment will perhaps deter him. You may have no character, but if you're afraid of getting hit on the side of the head with a baseball bat, you'll act right. It's real simple. And so you can have a judge with no character, but if he knows that there's a body that'll jerk his chain if he gets off base, he's going to act right even if he doesn't want to. And see, that's why Jefferson on 3 occasions said impeachment was a scarecrow. Put it out in the middle of pasture, it'll scare the other guys off. You'll find that the more often, in history, the more often you have an impeachment investigation, the less often you have to have impeachments. Because it reminds judges you're accountable. We'll call you here in front of this legislative body and you're going to answer to us for that decision. I'm not going to make a crazy decision. I don't want to have to end up answering to that body. It always works. The more impeachment investigations you have, the less impeachment you have to have. So that's the 5th myth. I'll give you the 6th one here real quick. The 6th myth is that primary responsibility of the judiciary is to protect the minority from the majority. Now, I'll tell you how this works and don't go into racial minorities here. You think any philosophical minority that's out there. And let me just show you one. I'm going to show you a religious minority. One of the things that I've dealt with, I've been involved in 7 cases of the U.S. Supreme Court, they all deal with the religious expressions. We went through a period of time in the 80s, the 90s, and the first part of the 2000, about 25 years, we dealt with 10 Commandments cases. And we lost them. We lost 5 out of every 6 cases of 10 Commandments. We couldn't display them in courtrooms. We couldn't display them in classrooms. We couldn't display them in parks. We're winning now. We're winning. I think we've only lost 1 case out of the last 14 or 15. But what was happening for 25 years that we were losing these cases is that there was a key phrase that every plaintiff would use. Whenever I see those 10 Commandments, I feel like an outsider in my own community. I feel like I'm part of a minority. And the court said, hey, if you feel like an outsider in your community, we'll make everybody else stop so that you don't feel like an outsider. So all you had to do was write a case out that said, I feel like an outsider in my own community. And the court says, that's why we exist, is to make you not feel like an outsider. So we lost every 10 Commandments case. Now, significantly, in those cases, here's what the courts regularly said. It says, the purpose of the Bill of Rights is to protect the minority from the majority. Now think about that for a minute. Bill of Rights has nothing to do with minorities and majorities. It has to do with inalienable God-given rights. Right. I have the right to free speech not because I'm in the 3% or I'm in the 97%. I have the right to free speech because I'm a human being. It's a God-given right. It exists for every single person. I have the right to exercise my religion not because I'm in the majority or the minority, but because I'm an individual and I have a God-given right. I have the right to keep and bear arms not because I'm in the majority or the minority. Bill of Rights has nothing to do with minorities and majorities. It has to do with individual rights. It doesn't have to do with group rights of minority or majority. So to say the purpose of the Bill of Rights is to protect the minority from the majority means the purpose of the Bill of Rights is to make sure the majority never wins. Because if it exists to protect the minority from the majority, if you're the 2%, you're going to win every time in court. See, if you're the 49%, you'll win every time. We've got to make sure the majority never wins. That's what comes through, and that's why we lose case after case. It's called a dissenter's veto. Guys found out all I have to do is object, and if I object and tell them I'm part of a minority, then they'll make everybody else stop, so I won't be offended. So that philosophy is a real problem. Now, we see it throughout the judiciary in a lot of ways, and by the way, the Constitution does exactly the opposite. There's nothing allowed to go through in the Constitution under a minority vote. Everything is a majority vote. You have a 60% vote. You sometimes have a 67% vote. You have a 3/4 vote. Everything in the Constitution requires some majority or above. That's why, by the way, the Founding Fathers did not allow filibusters. A filibuster puts the minority in charge of the majority. In the U.S. Senate today, 40 votes beats 60 votes every single time. Understand how that works? We don't pass a bill because we got 51 guys with powers the minority more than the majority. That's why we never allowed filibusters until the late 1800s. It's the first time it comes into Congress. So the principle, and the guys at the Constitutional Convention, and even the first presidents, I mean, you take Washington and Jefferson, now these guys are from different political parties. Washington's a Federalist, he's an anti-Federalist, and they both said the identical statement. They said the fundamental principle of our Constitution requires the will of majority prevail. Now, the only time the will of majority doesn't matter is when it's an inalienable right. Your right to anything God told you to do has nothing to do with whether you're a majority or minority. That's what the Bill of Rights is about. If it's not part of the Bill of Rights, it goes down to whoever gets the most votes. That's how we choose presidents. That's how we choose dog catchers or anything else. The majority wins. That's just the way it is. Now, having said that, look at the Supreme Court on a number of issues. Take, for example, the position of gay marriage. Right now, 68% of the nation says we think marriage should be between a man and a woman. 32% says no, any combination. Who wins, the 68 or the 32? Right now, 32 wins courts all over the land. Because, see, the 68 majorities are evil. You can't have 68. Take the same thing with something like school prayer. Do you know what the percentage is right now? 82% of the nation thinks we should have daily spoken voluntary prayer in public schools. Do we? Now, who's more important, the 18% or the 82%? 18%. See, that's the court becomes anti-majoritarian. Same on creation evolution. Do you know right now, do you know what percentage of the nation thinks we should teach creation science in the public schools? 68%. But the 32% win every time. Now, 68%, that's a landslide in political terms. If somebody got 68% of the vote, they have just kicked somebody's tail. We kick tail on every issue, but we don't get any of it in policy because judges get final word. Same with abortion. Do you know what percentage of the nation supports abortion on demand, the way we have it now? No limitations, no restrictions? Only 24% of the nation. But guess what? Abortion on demand is national policy. It's 76%. Those are bad guys. You have the same thing when it comes to Ten Commandments displays. Current numbers show that 76% of the nation think we should display the Ten Commandments in schools. We can't. 24% wins. The same thing with Pledge of Allegiance. Now, we're starting to win this one. We lost the first several cases, but that's a 90-10 issue, and we were still losing on the 90% side. So that's a mentality that we put up with. No, the judiciary exists to protect the rights of minorities with a philosophical, racial... No. The best protector of the rights of minorities is the people themselves. And just as an example of that, if you take the position of the courts on protecting the minority, let me skip through this real quick because we're running out of time here. All right. Who is the better guardian of Congress or the courts when it came to segregation? Congress did in 1875. The court didn't catch up with them until 1954. Same thing on slavery. Congress passed a law, said we're not going to put up with slavery here. The court said yes you will. You're going to have slavery everywhere. You have the same thing with the poll tax. Do you know a number of legislatures tried to end poll tax and the court would not let them? The court kept ruling that poll taxes for races was fine. No problem having poll taxes. Finally passed a constitutional amendment because the courts wouldn't get it right. You also have the issue of civil rights. The first 23 civil rights laws that passed through Congress were all struck down by the courts. No, we think slavery and racism is a good thing, Jim Crow laws. You have the same thing with voting rights. Voting Rights Act's the same way all the way through. It finally took Congress because the courts wouldn't do it. I mean, the court said, no, white-only primaries are fine, not having blacks on the ballot, we don't have any trouble with it. The Supreme Court upheld that in a number of decisions in the 1930s, 1940s, 1950s, and 1960s. Finally got a legislature to pass the Voting Rights Act and end that stuff. It wasn't the courts that ended it, it was the legislature that did it. So this nonsense that only the judges know how to protect minorities, that's nonsense. People do a great job of protecting themselves and protecting others around them. I don't know of anybody who wants to impose their will on people who don't want their will imposed. You know, whether it be 83% of the nation says they're Christian, 2% says they're Jewish, 1% says Muslim. I don't know of any Christian of the 83% who wants to force Jews to pray a Christian prayer or force Muslims to pray a Christian prayer. We're going to protect their rights. That's the rights of conscience. Majorities protect the rights of others very well, given a chance to do so. So those are the 6 myths. Let me review them just real quickly as we close out here. First myth that is pure nonsense is 3 branches are co-equal. Don't buy that. Second myth is judiciary is an independent branch. That's not true. They're not an independent branch. Third myth, elections make the judiciary political. They're already political. Elections have nothing to do with it. Only judges are capable of determining constitutionality and their primary responsibility is judicial review. That's not true. The 5th myth, federal judges hold lifetime appointments. Not true. 6th myth is judiciary is responsible to protect the minority from the majority. Not true. So these are things that shape the way we look. So as you guys go into judicial reform here in Tennessee, don't let them talk you into things that are just putting a Band-Aid on a Band-Aid. Go back to your starting point and say, here's the principles we ought to be upholding. These are the ones we want to get back to judges being accountable. And moving from the Tennessee plan to the Missouri plan does not make judges accountable to the people, period. It just doesn't. By the way, in the last 6 years, we've had 24 states that have moved back in the direction of electing judges, not appointing judges. The Missouri plan was a big deal in the 60s and in the 70s. It's a dying deal now because we found out those judges are political and we got to get control over them again. I will tell you, in Texas, we finally did that. And you know what? We don't have judicial activism in Texas, because every time they do that, we throw them off the bench. I mean, we had a federal judge who said, I know the state law says you can't have gay adoptions, but you can have gay adoptions. And that was the last term he got on the bench. We had another one that says, you know, even though Texas does not recognize same-sex marriages, we are going to recognize same-sex divorces. He didn't make it back for another term on the bench. So it's a good deal. Is you don't want a judge imposing his politics on you through his position. You want to choose the politics under which you live, and that's why elected judges are so important. Final word I'll give you. John Jay, Chief Justice, U.S. Supreme Court, said this. He says, every member of the state ought diligently to read and study the Constitution of his country. By knowing their rights, they'll sooner perceive when they're violated and be the better prepared to defend and assert them. I've taken you through the federal Constitution. Janice took you through the state Constitution. We need to read both of those documents and go over them and go over them and go. That's the standard that you want to shoot for. Thanks for letting me share with you guys.
Wow. Encyclopedia of knowledge. I hope you guys enjoyed that.